number 10, KCV Whitehouse Estates. Counsel, whenever you're ready.
Thank you, Your Honor. May it please the Court, Jeffrey Turkel for the appellants. I would like to reserve 2 minutes for rebuttal, please.
You have 2 minutes.
Thank you. Supreme Court's order in this case was issued in 2017, and a lot has happened since then, most notably this Court's decision in Regina and the First Department's post-Regina decisions in this case and in several other cases. What I'd like to do with my time here today is to discuss the fraud issue, the way this Court in Regina described the sole fraud-based exception to the 4-year rule, and how the First Department in this and other cases has dramatically expanded that, and I think, unfortunately, has disregarded what Regina has to say. The fraud-based exception began in 2005 in Thornton, and in 2010 in the Grimm case. This Court expanded and clarified on the circumstances where fraud would vitiate the 4-year rule and allow the default rent formula to go forward. And the Court specifically said that the 4-year rule could only be breached where there is evidence of a landlord's fraudulent deregulation scheme to remove an apartment from the protections of rent stabilization. As in Thornton, the rental history may be examined for the limited purpose of determining whether a fraudulent scheme to destabilize the apartment tainted the reliability of the base state.
So are you saying that unless it can be sufficiently demonstrated that the fraud is a scheme to deregulate an apartment, which I assume you're now going to say we concede that the apartment's regulated,
Yes.
Any other kind of fraud would be acceptable?
Well, not acceptable. It's certainly, all I can tell you is what this Court said in Regina. This Court said fraudulent scheme to destabilize. It said that 5 times. 5 times that phrase or variants thereof. So I have to assume that the Court was serious, that this was the sole fraud-based exception.
Does the destabilization have to flow immediately from that particular fraud? Can it be a long-term scheme that down the road, eventually, you might end up removing these apartments from coverage?
I mean, I think the Court, as the Court determining what the common law exceptions are to the statute, because the pre-HTS TPA statute doesn't really govern any of this, or doesn't speak to it. I suppose the Court could go that way if it wished.
Seems that Thornton, I think Judge Kaye there in Thornton is talking about potentially down the road,
Yes.
there may be even more grievous implications for the fraud
Yes.
beyond the immediate.
Yes, I understand that. What I would say is that if the tenant who came in as a stabilized tenant post this fraud didn't vacate the apartment for 30 years, there's no deregulation for 30 years, at least based on a vacancy. So if the Court wanted to go in that direction, I suppose it could. I would note, however, that the tenants never argued that there was a fraudulent scheme to destabilize in
And
this
let me
case.
ask you another question, because you're focused on the fraud, I understand why, but let me ask you a different kind of question. Is fraud the only basis? Strikes me that Thornton begins with, is the landlord's conduct a violation of public policy? And then goes on, that the fraudulent scheme there certainly is a violation of public policy. Can't we look at these cases, Regina being just one part of this on fraud, that there is an opening for examining the full breadth of the landlord's conduct to see if it is in violation of public policy, if not fitting within particular elements of fraud?
Well, what I would say is that, as I said before, the Court in Regina used the phrase fraudulent scheme to destabilize 5 separate times, and on 4 separate occasions, it described it as a limited exception. The other thing that I would point out is that the Court in Grimm and in Regina went out of its way to say that it has to be a fraudulent scheme to destabilize that would taint or make the base state unreliable.
Isn't that, counsel, really the point of Regina in those cases? It may be public policy, it may be fraud, but it seems to me what you're trying to get at is reliability. So how reliable is the information we have about the rent on the base state?
Yes.
There are other penalties for various misbehavior, right?
Absolutely, Your Honor.
So it seems there's 2 ways you can do that here. One is fraud. Fraud somehow made the rent that was actually being paid on the base date unreliable, or we just don't have enough information provided to be able to determine that. right?
I understand both points of view. I think, you know, if you look back on Regina, the first thing that the Regina court says is, let's start with the statute, because the statute's what the legislature has promulgated, and we're supposed to be implementing the intention of the legislature. And it started out by saying, we're looking at the pre-HSTPA statute. And what we see is there's a 4-year rule, that you look at the base date 4 years prior to the complaint being filed. That is the base date, okay? And the court created the exception, the common law exception to the 4-year rule, because it's unfair to use the base date as the be-all and end-all for all future.
But again, that rule that was crafted there was done so that you can get it to a conclusion as to whether or not the rent paid on the base rent date was reliable or not.
Yes.
Not so that you could go back and reconstruct various rental payments.
Yeah, I mean, one of the key aspects of Regina, which has a real impact on this case, is that the court declared the reconstruction method to be unlawful precisely because it violated the 4-year rule.
Let me ask you a small question about the record, because I wonder if this is just a sort of very nice wording dispute. I think you've said that there are, for 2007, there are 55 leases that have been produced relative to these apartments, and the tenants are saying that those aren't in the record. And I'm wondering if both are true, in the sense that the reason those aren't in the record on summary judgment is because at the time the summary judgment motion was filed, Regina hadn't been decided. And so what the rate was in 2007 wasn't conclusive the way it would be after Regina.
Absolutely.
Is that right?
I mean, the irony of this case is that we're kind of trying to put Humpty Dumpty back together again, because at the time that this case was decided by Supreme Court and prior thereto, when the tenants moved for summary judgment based on document disobedience or alleged document disobedience, everybody was laboring under the reconstruction method. And if the issue is, well, going to the issue of whether these documents are in the record, when the tenants move for summary judgment, they move for summary judgment based on alleged document disobedience, not fraud. And they said to Supreme Court, they said, we have painstakingly, that's the word they used, painstakingly gone through all the documents that the owner has produced, and we have compiled a schedule showing what was produced. And if you look at page 256 of the record, what you'll see is a list of apartments, and I would just point out in one particular case, page 256 of the record, Exhibit 5, or Exhibit V, summary of documents provided by defendants. On page 257 of the record, they have this long list. The second one down, the notation, Apartment 1D, the lease commenced December 1st, 2007. It terminated, November 30th, started on December 1st, 2006, terminated on November 2007, tenant's name, and the rent. That is the tenants saying and stating to the court that we have this lease. This is a list of leases that they already have. There are 41 such instances on this schedule, and then several months later, after we had produced another 10 or 12 or however many thousands of documents, they submitted a second schedule.
How do we know that's what that schedule is?
The tenants described it, Your Honor. The tenants went to Supreme Court, and again, based on alleged
So then are
document.
they essentially stopped from saying anything to the contrary?
Yes, yes. They created the schedules. They described the schedules to the first department. If you'll just bear with me for 1 second. They just said that the first department, they were painstakingly put together. You know, we went through this and we did an audit and we did all this. And they put that schedule in lieu of the 10 or 15 or 17,000 documents under the voluminous documents exception. And they went to the Supreme Court and they went to the appellate division. They say, this is good as gold. Take our word for it. We have reviewed the leases. This is a list. The first list is what's in the record, and the second list is what's not in the record. They put that list in the record. That list conclusively shows that there are at least 55 leases that were put in on the base date. Before the
And for
court of-
example, with the example, sorry, we're here again. With the example you pointed us to, right, I've forgotten, the woman's name was Claudia something or other. your understanding of their point in putting that in, where there's 3 leases and that's at just around the 2007 period, is that they
Right.
were trying to establish that there weren't leases from before that?
Yes.
Okay.
That's
I've
part of
got-
what they were
yes.
trying to do. I mean, according to them, it was a schedule of what had been produced. However we want to contextualize that, or...
But that was for the purpose of proving what hadn't been produced. Is that fair?
Well, the first list is, these are the documents we got from the landlord, and the second one, which was several months later, after much more discovery had continued, thousands and thousands of documents, that was a schedule of, as of this date, this is what we don't have. If you look at the 2 lists and you do the math, there are 55 leases. And the tenants, and I think it's unfortunate and regrettable, in the first apartment, they said plaintiffs painstakingly reviewed the records submitted by defendants on discovery, provided a detailed and accurate analysis to the court showing the deficiencies in the defendant's rental histories. Then they said plaintiffs' attorneys properly attached their motion as exhibits, so it's in the record, summaries of the thousands of documents provided by defendant. This was proper, and these summaries were admissible, and they did it, as I said, under the voluminous document rule. Now they claim, and again, I think it's regrettable, they say that these summaries, which I think have really backfired on them, raise merely the suggestion that some Bay State leases were turned over upon pretrial discovery. A suggestion is not enough to establish that these records were provided. They submitted them, they swore to their accuracy, and then when it came to bounce back against them, they say they're mere suggestions. Just the fact that they concede that some of the Bay State leases are there, I think is enough to warrant reopening this. On the issue of document production, I think Judge Gish...
Counsel, can we save the document production for your rebuttal time?
Certainly, Your Honor.
Thank you.
Thank you.
Good afternoon. May it please the court, my name is Ronald Languedoc. I'm appearing for the plaintiffs. Your Honors, the appellate division correctly held that the defendants' en masse retroactive registrations of these illegally deregulated apartments in 2012 was an attempt to avoid the court's adjudication of the issues and to impose their own calculations
But
upon the tenants.
how does that exactly happen if Regina says you look at what the actual rent paid on the Bay State was? So how does that affect the reliability of that calculation?
Well, it affects the reliability of the calculation in a few ways. First of all, it's not just a question of producing a lease that was in effect on the Bay State, but it's the full rental history thereafter. Because the rent stabilization code talks about 3 possible bases for applying the default formula. One being fraud, the other being the inability to produce a Bay State lease, and the third being inability to produce
But
rental history.
Isn't that the problem, that you were pursuing the default formula in a pre-Regina litigation, and suddenly there was a game-changing decision that made the default formula, I don't know if it's totally irrelevant, but somewhat less relevant to something like what Judge Garcia was suggesting, just show us the lease and what you were paying on the Bay State?
And if you know let's say, in a hypothetical, you know exactly what the rent was on the Bay State, isn't the formula then you are entitled as landlord to whatever increases you would have gotten under the rules going forward? And so the
Correct.
difference between what you paid and what that calculation is are the damages. So what's missing in the case where you can establish what was paid?
Well, what is missing is not just the Bay State, but then the subsequent rental history. Then there's the fact
And
that...
that's just what's actually paid, though. So that's a proof failing, you're saying?
It's whatever leases or renewal leases went into place, whether there were changes of tenancy, whether there were individual apartment improvements or MCI
Subsequent to the Bay
increases.
State.
Correct.
So that's a discussion about what allowed increases might have occurred following the Bay State.
Correct.
But the goal that you were pursuing in this litigation was to try to establish the rent on the Bay State using the reconstruction method.
That was the goal in December 2015 when we brought the motion.
Right.
That was the argument that we made based on the limited authorities that were available at the time. Then by the time we got to the appellate division, which was 2021, Regina had already been decided, the appellate division, fully cognizant of Regina, accepted the Supreme Court's determination that the owner's actions in 2011, 2012 were designed to obviate an adjudication of the legal rents, and thereby that combined with the landlord's failure to produce the leases on the record.
And as to that first thing, I assume you take the position that that was not an overly lenient view of fraud, at least as we meant it in Regina, correct?
An overly lenient
In other
view.
words, that their effort to reconstruct the rent the way they did,
Right.
their conclusion that that was fraud, you don't think that that was unwarranted conclusion on their part?
No, that was fully warranted conclusion based upon what the landlord
And,
did here.
and why, given the elements of fraud that are so frequently stressed and I think cited in the footnote in Regina, why is that not the case?
Well, the footnote in Regina, the footnote 7 in Regina, it relates back to a text in the majority opinion in which they're distinguishing between the actions of owners in cases like Thornton and Grimm and the actions of the owners in the cases before them, where in the four Regina cases where the court had a complete rental history and there was no serious allegation of fraud. So I would argue that the footnote 7 has been misconstrued by the landlord to mean that the pleading requirements of CPLR 3016B are applicable and so on. I don't think that was the court's
So it's
intention.
just a pleading issue, the specificity of the pleadings.
Well,
It doesn't change the substantive law of fraud.
well, it's not that the tenants must prove a common law fraud claim in order to establish that there was a fraudulent scheme. They must prove that there was a scheme, that it was evading the rent stabilization law in some way. There's no one-size-fits-all approach. That there's a variety of circumstances. For example, what was done in this case, which largely was things that were done after we filed the action, but were obfuscating of the record and made it impossible for anyone to calculate what
But
the
I'm
rents
still
were.
having trouble with that, because all the actions complained of by the landlord took place, I think, at the end of 2011, 2012,
Right.
early. So the 4-year look-back period, as I understand, is October '07 to October 2011.
Correct.
So it just seems like a proof issue to me then, because whatever they did in late 2011, early 2012, how does that affect what the records are of what was paid over that 4-year period?
It does not affect the records of what was paid over that 4-year period if those records were available and produced. And yes, certainly they did turn over some number of leases in effect in October 2007 in the course of the
So again, my
discovery.
question then is, why isn't this a proof issue and why is it a fraud issue?
Well, I think it's both. I think it's a combination of circumstances that, which I think may have been where some of the questions that were asked to my opponent earlier were addressed, that it's a combination of circumstances whereby the owner recalculated the rents to a much higher amount,
But what does
registered
that
them.
have to do with what was paid in the 4-year look-back period?
It doesn't have to do with what was paid in the 4-year look period.
Right.
It's the fact that it's not possible from the record we have
As
to
regards the,
ascertain.
as regards the registration of the inflated rents, wasn't there then a letter that went out jointly that said disregard all of this? So I'm having trouble understanding how you can rely on that as fraud when somebody says, wait a minute, time out, the court's going to decide this,
Right.
disregard.
There was a letter that was sent out in January 2016, excuse me, January 2012. And then in March 2012, the landlord went ahead anyway and filed all of these registrations and then started a process of having tenants sign these illegal leases. And from what we know in the record, 29 tenants refused to sign them. That presumes that there must have been some approximately 50 people who did probably sign them. We don't know the number. So the letter that was sent had no effect, apparently. It's not clear in the record.
But if we decided in Grimm that an increase in rent can't be a colorable basis for fraud, what else are you alleging? Like, what in the record are you stating?
Well, we're alleging a scheme by which apartments that had been unlawfully deregulated were ostensibly placed back in regulation, but at much higher rents than what had ever been charged and what the owner was entitled to ever collect. And that scheme has not, as far as we're aware, to this day, has not been rectified.
Well, I thought that Justice Singh issued an order that set interim rates.
The Justice Singh issued an order in 2014
Yeah.
directing that the rents not be increased.
And that's been,
Without leave
that's
of
been in
court.
effect since.
That has been in effect, that was in effect until, I believe, 2021, when then a subsequent interim order was entered, which is in effect as of today. Yes, that's correct.
So let me ask you, I take it that even the defendants would say that there are certain of the apartments at issue for which they haven't produced a lease that was in effect as of 2007.
Right.
So what do you say should be done as regard to those?
Where a lease was not produced as
Yeah.
of 2007?
Where we don't know, let's assume hypothetically, we don't know what the rent was in 2007, then what happens?
I think, well, what is supposed to happen under the rent stabilization code is that the court would apply the default formula, which is what the appellate division held.
And is it your view that there are at least some apartments as to which that information for 2007 is not available, and therefore you have to use the default?
Absolutely.
Okay.
Absolutely. Yes.
Thank you, Counsel.
Thank you.
Counsel, is there more discovery that needs to be done to determine what the base rent is on those, I don't know what the number is, of cases of apartments where you don't have leases?
Right. I think as Justice Gish suggested in her dissent, because this whole case was litigated at Supreme Court, the discovery demands, the discovery orders and Supreme Court's order as to what was submitted and what was not submitted, it was done under the wrong methodology, the reconstruction method, which was found by this court in 2020 to be illegal. It was overly broad because under the reconstruction method, the base date is the last date that a rent-stabilized tenant was paying before the deregulation. That base date is not 2007 for these 72 apartments. It could be 2002, 1998, 1994. So they were asking for thousands and thousands of documents that they had no right to ask. I think given the rapidly evolving state of the law regarding what the proper base date is. I mean, when the court found that we were in discovery disobedience, it was using the wrong base date. I think the fairest thing to do is to remand it, as Justice Gish had suggested, for any further discovery that's necessary. Now that we know what the proper base date is, we can do all of this correctly.
I guess the only problem I have with that is that you described the request as overbroad, and I assume you tried to produce everything you had from 2007, right? I mean, you didn't withhold any leases from 2007.
I cannot say, Your Honor. I know that their schedule showed that at least 55 were submitted.
Right.
It's possible that there were more submitted. I think it
But those would already have been produced in discovery.
right. And I would also point out that
And this case has been going on a very long time. I take your point that the discovery demand was extraordinarily broad and you had to produce a lot of things, but it strikes me as improbable that you have leases for 2007 for some apartments that you haven't yet produced.
I think that, I understand Your Honor's point of view. I think that, again, given the initial mistake about all of this, that discovery can be concluded very briefly so that the case can proceed under the right discovery rule, under the correct base date.
Is that because there's no fraud? When you say the correct
I would
base date? I'm
respectfully
just trying to
submit-
clarify the genesis of that statement. When you say we know the correct base date.
We
We
now...
know that because
Oh,
there
yes,
is no
assuming there's
scheme,
no
there is no
fraud.
fraud.
Yes.
So if the court disagreed with that, do you lose?
Yes, under a standard that I believe was overly broad and that disregarded. I mean, I also have a problem with the fact that the tenants did not argue fraud in Supreme Court, and that we specifically argue in the appellate division that the tenants never alleged fraud, and they certainly never alleged a fraudulent scheme to deregulate.
Counsel, this fraud doesn't affect the base date, right? It just
Not
affects...
in this case.
But it doesn't affect the base date in any case. I mean, the base date is the base date, right? I mean, fraud affects the reliability of the actual rent paid on the base date, as I understand it. You'd still have an October 2007 base date, even if there's fraud here, wouldn't you?
Well, if under the Regina conceptualization, there was a fraudulent scheme to deregulate,
You can look further back.
that you could look further back, that tainted the base date, has to taint, has
It
to
has to
actually affect it.
taint the rent paid on the base date. It doesn't taint the base date.
No, it taints the reliability of the rent paid on the actual base date. Unless the court has any further questions?
Thank you, counsel.
Thank you.